What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Welcome back to the Zona Law podcast. This is part 2 of the Eviction 3-part series, which gets very exciting to say because it sounds very professional, even though we're making the stuff up as we go for the legal podcast. I am Mark Zinman with Zona Law, and I'm joined here today by Scott Baluha, one of our attorneys as well.
Great to be back again, Mark.
And if you'll notice, we are wearing the same ties, which means we're probably doing the same day as the first series from this one, because consistency and staying on top is what we're trying to provide here for clients. So we did the first series, the first podcast from the series, which was on the pre-eviction filing. What do you do? What kind of notices? What kind of issues you're seeing? Now we're jumping over to the eviction. What are we going to talk about?
Well, we got to talk about collection of evidence, make sure that we have everything that we need in order to move forward. That means all your documents in a row. We got to talk about what actually happens at the eviction hearing, and then what the potential outcomes are, and what happens if judgment is found in favor of the landlord or not.
Yeah, and so we talked before about the kind of general 4 types of evictions you maybe file: your non-renewal, your non-compliance, your non-payment, and your immediate. So we're not going to harp on those too much here today. We'll kind of go over them, obviously, because they get touched on. But we're talking about really about the eviction process, where you send a file over to us, what we're looking for as attorneys, what the court's looking for, and obviously it comes down to evidence. So there's really 2 things we're looking for. One is what the court requires us. So our courts now require, when we file an eviction action for any kind of issue, we have to attach a copy of the lease and a copy of the ledger that actually gets served to the tenant.
Correct, and a copy of and the notice that was served to the tenant as well. And if we don't have those documents, then there's a possibility that the court could determine that the landlord didn't do its job, and then the case would end up getting dismissed. There are also other additional requirements that arise from the Arizona Supreme Court administrative orders. So you're going to see other documents that you're going to receive from us that you're required to fill out, certain attestations, because we have to put those into the complaint before we can file it.
Yeah, for example, whether or not you have a federally backed mortgage or not is one of the check boxes. We walk clients through that, and they can actually, they're effectively swearing under oath that they're not, whether they've gotten rental assistance and how much. So we have a declaration for that, and that's one of the forms that we require before we even file the case.
And what's incredibly important to remember is if you do not know the answer to any of those questions, do not attest on that declaration to what it is you're signing off on. Go to your regional manager, go to the owner, go to somebody else who has the information, because what we don't want is to go ahead and file a complaint that has an incorrect attestation in it.
Yeah, and that goes from the most basic things to how did you serve notice? If you hand deliver it, tell us you hand delivered. If you sent certified, tell us you sent certified, and give us the certified mailing slip to whether you're federally backed or not. And if you need to, the best answer, of course, is contact your lender, because the lender is the one that should know. So those are kind of the nuts and bolts of what we're looking for before we file, but that doesn't get to the evidence. I mean, what kind of evidence are we looking for, and what would even constitute evidence in most of these cases?
Right, and if we're talking about non-payment of rent, that's pretty simple. It's a notice that you served, a copy of the lease, and the ledger showing that you haven't received any payments. But it becomes much more complex when you have a situation arise that's a criminal act that you would serve an immediate termination notice for. So let's say, for example, you had a situation where there was an assault on property, where one of the residents is accused of having assaulted somebody in the common areas. So what do we have to support that? We're often going to ask for a copy of a police report. We're going to want to know the names of any individuals who saw the attack. We're going to want to know whether or not the victim is going to be willing to testify in that situation. Essentially, for immediates, that's what we're looking for, but it could end up being much more expansive. Do you have any other examples?
No, I think what it comes down to is working with the clients on that, because a lot of clients will just say, oh, well, I have the police report number. Well, the police report number just shows us that the police came out. It doesn't tell us anything in terms at all what actually happened. So in those cases where we always suggest, obviously, clients go get the police report, but the best evidence for assaults on property, fighting in a unit, gunshots going off, is testimony from other residents. And I will tell you, I am so surprised how many people shoot off guns by mistakes in apartments, and you have like a bullet hole going from one unit into the next unit. Yeah. And yes, that's an immediate. You can never let that happen again. because in Arizona, you as the landlord aren't liable for that. But if you let that person stay, you potentially could be. So you really need to take action, and you need to gather the information to be able to present to a judge and say, this is actually what happened. Here's the people that saw it.
And it doesn't matter that it was accidental, because that's the number one excuse that people will give for damage to the property. Well, I accidentally started a kitchen fire and it caused significant property damage. I accidentally discharged a firearm. That's not an excuse, because from the perspective of the landlord, you need to protect the landlord from any future suits if anything were to happen with this particular tenant in the future. And the only way to do that is through an immediate if it's severe enough.
Yeah, and we're not talking about like small damage where the person breaks a fridge handle. We're talking about somebody that starts a grease fire and puts in $20,000 to damage. Cabinets have to be replaced. Floors have to be replaced. I mean, the extreme things. That's what the immediate's for. What about non-compliance? What kind of, let's say, obviously you got the unauthorized occupant. You have to have what kind of evidence?
Well, sometimes, and we've seen this happen before, you'll end up getting evidence showing that the person is now receiving mail at the community. That's a pretty good indicator that that person is residing there. You have, again, other residents that are saying, I've seen this person coming in and out. You have a maintenance person who's routinely doing the rounds and has gone in there to just fill work orders. Oh, well, I saw this person. It's clear that their personal effects are there and that they're living there. That's great evidence. You want to have that to be able to show to the judge, because the judge is going to have to make a determination as to whether whatever allegations you made in the notice are true or not. And if you don't have good evidence, then the judge isn't going to believe you, and your case is going to get dismissed.
Yeah, and we didn't say it yet, and we'll kind of keep going with these different options on non-compliances. But on a non-payment of rent case, generally, you don't have to appear for an initial hearing, right? In an eviction, you have an initial hearing, and if there's a dispute, then you'll have the trial. For non-payment of rent, we don't require clients to be there for initial. However, for non-compliance, we require them to be there, not for non-payment. Non-compliance and immediates, we want our clients there for the initial because the judge wants to hear from somebody with personal information. We're your attorneys. We'll fight for you. We'll argue your side, but we don't know the facts. We didn't see the incident. Thankfully, I haven't gone into the unit with cockroaches. I mean, that's just not my job. I'll argue the case. You bring the facts. You present them. I'll get to ask the questions. But we need you there to be able to give credible evidence to the court. And so we need that on the initial.
Right. And once, for some types of immediates and in certain courts, the judge will actually require that we move forward with the trial on the day of the initial appearance. So if you're not there for the initial appearance on non-compliance or an immediate, a case might get continued or it might get dismissed. That's why it's critical that you appear for non-compliances and immediates.
Yeah. And so going along a bit further with the non-compliance is what could be, obviously you could have an unauthorized pet, pictures of that animal, testimony from neighbors. What if you have partying too much noise? What kind of evidence are we looking for?
It would be fantastic if we were to have some type of video or audio recording from neighbors or even from the property. Sometimes there are cameras that are throughout a community that might pick up that type of activity. So if you cut out little segments showing the excessive noise or the partying or the excessive guests coming in and out of the property, that's extremely helpful and very convincing for a judge. Just think about it from a practical perspective. I see this video, picture's worth 1,000 words. It's much easier to show it rather than have numerous people testify about it.
Yeah, that is a good question, though. They say a picture's worth 1,000 words. I'm not sure what a video's worth, but let me just tell you, very convincing in front of a judge because there's just no argument. I can see it with my plain eyes. I mean, I've seen so many videos of tenants damaging properties, and it's just, it makes it so much easier. So prior to the filing of the case, that's what we're looking for as the attorneys. We need the evidence that we need to know we have a good faith basis to not only file the complaint, but actually succeed as well. We're looking to gather all of that before we filed. And so we'll work with the manager saying, okay, well, we need this still, or do you have this available that you can get to us? Once you get to filing of the complaint, obviously our office, or if you do it yourself, I mean, you can file your own lawsuit. Generally, you're in court within 7 to 10 days from that filing. What are the options that happen at that initial hearing?
Well, there's 3 different outcomes. The first is the tenant doesn't show up. If a tenant doesn't show up, it's usually a default judgment, and if it's a non-payment of rent or a non-compliance, you get a writ of restitution, which allows you to get possession of the property back 5 days after the entry of judgment. The next option is that the tenant shows up, and usually the judge will ask, well, did you read the complaint? Do you understand the allegations? Do you agree or disagree with them? If the tenant says, well, I agree, I didn't pay the rent, or I agree those unauthorized documents were there, then a judgment would be entered and the same process for a default judgment would happen. Sometimes a tenant will plead not guilty. They'll say, no, that's not me, or I paid the rent, or I wasn't noisy, or that criminal act didn't occur. In that circumstance, usually the judge will set it for trial within a few days after the initial appearance, and then everybody will have to come back in order to conduct the trial.
I think of it like almost like a triage if you're in a hospital, right? The initial hearing is a cattle call where a bunch of people show up for all their different cases, and the judge is going through and saying, legally, their job is, does the person present a valid legal defense? And that's what the judge is looking for. So they'll have this kind of dialogue question the tenant about the facts, about the non-payment, the non-compliance, and they're trying to figure out whether there's that legal defense. If there's no legal defense, judgment will enter that first day on the initial hearing. If there is a legal defense, the matter gets set for trial. Like Scott was mentioning, give me an overview of what the trial looks like then.
So the trial is a very formal way of going through and presenting the evidence so that the tenant has an opportunity to defend themselves and the landlord has an opportunity to present the evidence to the court. If the landlord has filed a case, the landlord will go first. The property manager will have to provide testimony by the attorney questioning the property manager. We'll go through the lease, the ledger, the notice that was provided, and then through stepping through it one by one, explain to the judge why we're entitled to get possession of that unit back. The defendant or the tenant would end up having an opportunity to cross-examine you as the property manager, so you'd have to be prepared to answer questions about what you've testified about, and then the judge will make a decision. That's a very high-level view, but maybe you can give us some more details about having a witness testify. What does that actually entail?
Yeah, truly, every time I go into court for a trial, I just hope it doesn't turn into Judge Judy, where you have these people just like randomly screaming at each other, where you're getting cross-examined, then you're questioning them back. None of that is supposed to happen. It's really supposed to be a much more formalized process where I, as the attorney, know what evidence we need to get out, and I ask the manager or the witness specific questions to elicit that information. Now, I'm not going to go into the examples of the types of questions you can have because, that's, frankly, it'll bore you. What's important is I'm there, I know the story that needs to be told, and I'll ask you questions to get that story out. But the testimony, the suggestions I always give to our clients ahead of time is keep your answers short, to the point. Do not get emotional. This is not an emotional from your side thing. It is part of the business, unfortunately, that you guys have to go through, and just testify to what happened. Have your witnesses testify what happened as well. And what's important is you just make sure you answer the question that's being asked. If you go off point and start rambling on things that have nothing to do with the issue we're here, one, it's going to confuse the judge. And then two, you get cross-examined, the person can ask you about all of those things that have nothing to do with it. And it takes away from really what's the meat and potatoes of your case. These aren't, with evictions, they're very focused in issues. There's a non-compliance. There's a non-payment. It's not like a medical malpractice case where there's all these other things going on. So you're allowed to really focus on what the actual issue is, which is critical for us.
And while it might be an anxiety-inducing event to have to testify in court, it is a necessary part of the process. And the number one concern that I always see from managers is that, the tenant's going to have an opportunity to ask me questions, or their attorney's going to have an opportunity to ask me questions. But there's a really simple way to look at it, and there's no rush. Take your time in answering questions. If you get a cross-examination question, you always pause for a second or two for two reasons. One, to give your attorney an opportunity to defend you if it's a question that the tenant or the tenant's attorney isn't supposed to be asking. And two, to gather your thoughts. Think about what your response is going to be. Yes, no, I don't know. Keep it as focused as possible so that, like Mark said, you're not talking about 1,000 other things that opens the door for all these other topics that have nothing to do with the case being brought up. It's narrowly focused. We're hitting on non-payment of rent. We're hitting on a criminal act, non-compliance. That's what we're here for, not about 3 months ago, you didn't give me my rent statement quick enough, right?
And people go down those, and I'm always just like, objection, relevance, and it's never good when you have to object to your own witness. It's about staying on point, and that's critical. And that breath that he mentioned about taking a pause, it's to make sure that you're giving an honest, truthful answer. Even if you think that it's something that's damaging to your case, you're on the stand. You be truthful about what it is, and it's our job as the attorneys to come back and have you explain later as to why something happened that may sound weird up front, but then you can explain, we did this, or, we did that, and you really walk it through when we're the ones questioning you as opposed to being cross-examined. But being truthful, and the hardest thing I think what people find on the stand, truthfully, is admitting they don't know the answer to something. But there's nothing wrong with that.
Yeah, people feel the need to want to over-explain if there's something that they don't know. It's okay if you don't know everything. It's better to say, I don't know, and then have your attorney ask you some clarifying questions rather than to guess at an answer. That's the worst thing that you can do. Never guess at an answer. Well, I think they moved in September, but then the lease agreement says they moved in July. Well, now the judge is going to have some questions about whether or not you're a credible witness, right?
Yeah, it just doesn't look good. So after, like Scott was mentioning, both parties get opening statements. The plaintiffs go first, which in most of these evictions obviously is the landlord. Then the tenant gets to put on their side. Then we get closing arguments. We kind of get to sum up and really give our story of the case, right? What we think the evidence showed, and get to argue that to the judge. And at that point, in most evictions, the judges will just rule right then and there.
Right. It's rare, but in some of the more complex cases or cases that have more protracted litigation that have taken several hours or maybe sometimes days to have to get through all the testimony, the judge will take it under advisement and then make an issue a ruling from the bench or later down the road. Now, there's basically two different outcomes. It's you get judgment and you'll get a writ of restitution and possession of the property back. And the other option is the case gets dismissed. What causes a case to get dismissed?
I mean, in an eviction, and I think a lot of people don't realize it, it's the landlord's burden to prove the breach by the resident. Now think about it. The burden is on you as the manager, as the landlord, to show that you're right, that it's more probable than not that the tenant did this act, or the tenant didn't move out, or they shot the gun, or they failed to clean their unit for 6 months and it's disgusting. We've seen it all. That's the landlord's job. And so if you don't convince the judge, 51 to 49% that it's going in your favor, the case gets dismissed because you haven't carried the burden. Technically, a tenant doesn't have to do anything. They don't have to testify. They don't have to do anything. It's the landlord's job to convince a judge that these things have happened. And so that's where it comes down to. And when you have the judgment at that point, the judge will decide whether you carried that burden or not. If you carry the burden, you get the writ, which, spoiler, that's going to be series 3 on this podcast series. And if not, you'll get the case dismissed.
Right. And then there, like we'll discuss in part 3 as well, there's other remedies if the case got dismissed the landlord may have, as well as the tenant if a judgment was entered.
Yeah. So you guys, it's always a pleasure. We hope you appreciate the what we're trying to give you here for the information, and we wait to see you till part 3 next time on the Zona Law podcast.